Welcome to Cordell Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hello, and welcome to another edition of the Men's Divorce Podcast. I am Julianne Morgan, a management partner in our Dallas office. I have been with the firm for about 12 and a half years, and I have been practicing family law for 15 years. With me today, I am joined by Diona Potter, a lead litigator in our Marietta, Georgia office.
Hi, Julianne. How are you doing today?
I'm doing well. How are you doing?
Fantastic. Like Julianne said, my name is Diona Potter. I'm in the Marietta, Georgia office. I've been with Cordell since 2015, been practicing almost 16 years, been practicing family law for, in some way, shape, or form for pretty much that entire time. But I have been practicing family law exclusively since I started with Cordell in 2015.
Wonderful. All right. So the purpose of our podcast today is to educate you on interesting family law topics. We will not be providing legal advice, but if you would like to obtain some legal advice, then we want to encourage you to reach out and do a consultation with us. You can do so by giving us a call at 1-866-DADS-LAW, or you can visit our website at cordellcordell.com. All right, so today the topic we are going to be discussing is trial preparation, which is a very interesting, somewhat complex, and arguably one of the most important events that you can prepare for. So let's start, Diona, just with where do you even begin with trial preparation? Like, at what point in your case? When should you start thinking about it? When do we, get the ball rolling with it?
Yeah, absolutely. Like Julianne said, trial prep probably is one of the most important aspects of your case, even though most cases settle. Everything that we do, throughout your case is kind of leading up to potential litigation. And, it basically, you need to start thinking about preparing for trial pretty much at the beginning of your case.
Right.
One thing I always tell my clients, because, you can't prepare for trial a week before trial or 2 weeks before trial as a client. I always try to talk to my clients about it as soon as possible in the case. One kind of pointer that I always try to give my clients is, look, anytime you're talking to me, just pretend that the judge is listening, because it can give you, kind of plant that seed in your mind of being mindful of, okay, well, how am I coming across? Am I getting my point across clearly and concisely? And I understand that family law issues are super emotional, and sometimes kind of being able to keep yourself in check when you are talking about these issues can be helpful if and when you ever do get in front of a judge and you're testifying.
Right. To your point, the majority of family law cases, we typically are able to reach some type of an agreement, whether that's informally or we attend mediation or settlement facilitation. But from a strategic standpoint, you really have to start from day one of preparing for the chance that you could end up in court. It isn't something where, like you said, a week or 2 weeks or a month out, because you're going to make some strategic decisions along the way, knowing that if you do end up in a courtroom, you're prepared for that, and you've laid that foundation for it. So in terms of the advice that we could give to a party who may be in the process already, or thinking that their case could head in that direction, what is one of the most important pointers we can give them of working with their attorney and what they would need to do?
Yeah, I think one of the most important pointers is you want to listen to your attorney. I mean, your attorney has ostensibly been in court before. Your attorney should have an idea of what judges are expecting, what information they are looking for. So when your attorney is giving you advice about, information, let's talk about, make sure you talk about these facts. You really want to make sure that you listen to your attorney. I think another difficult conversation that we have to have sometimes with our clients is to try to explain to our clients, look, I understand you're frustrated, I understand this is emotional, but when you're on the stand testifying, you really want to make sure that that you are keeping yourself in check as much as possible. And so I think you really do want to listen to your attorney, because your attorney is really there to guide you, to help you put up the best case, the best testimony that you possibly can. And, we've been there, and, we definitely want you to testify effectively. We want the judge to like you. We want the judge to connect with you. And so, anytime your attorney is giving you pointers, just know that it's coming from that place of, how can I put up my client's case as best as I can?
Right. I agree. And I think it's important for clients to know, as their attorneys, it's our job to have those hard conversations with them, and to navigate with them through some of what might be some harder facts. How are we going to handle that testimony? And it's not always what they want to hear, but it's our job to make sure that we're preparing them, and that we are putting them in a position that if they do end up in trial, that they are ready for some of those harder questions, and what is probably to come. And I think reminding them that our job is to advocate for them. Like, that's what we are trying to do. But, so listening to what we have to say, the advice we have to give, it's in their best interest. It's just sometimes hard to kind of sort through some of those more difficult conversations. So,
absolutely.
Yeah. And I think, also, yes, they need to listen to their attorney. And then I think also, using their attorney as a resource, asking their attorney for advice, feeling comfortable going to them, with questions. Kind of give us some of your thoughts on that, and how a client can use an attorney as a resource for that.
Right. Definitely. If this isn't information that your attorney is kind of voluntarily providing, it definitely is something that you should ask your attorney about. How do I come across? How can I come across better, if and when I'm testifying? What are some things that I can do for my testimony to be effective? So, don't be afraid, and I think another aspect of preparing for trial, make sure your attorney knows everything, kind of good, bad, and ugly, because believe me, we do not want to find out something when our client is on the stand. You don't want to find out, about it through opposing counsel. So, it's important that you have that type of relationship with your attorney, that you can go to them, talk to them, like you said, Julianne, ask for advice. But also you have to, be able to kind of, bear it all as well. It's kind of like a doctor. If you don't tell the doctor what's going on, they're not going to be able to help you. And the same with us. If you don't let us know everything, the good, bad, and the ugly, then we're not going to be able to, effectively address it, and, ideally try to minimize it if possible.
Share some of those more, challenging facts, or, some of those situations or events that occurred that, that you don't want to have to discuss, but it's even more important that we know about them, because once we know about them, then we have the opportunity to discuss it and be prepared, and how best to respond, and how best to present yourself to the court, who's going to be hearing it. And yes, Diona, to your point, I think all attorneys have a few horror stories about being in a courtroom and being completely caught off guard by, something that opposing counsel asks about. And I think we immediately think, why would a client think that wasn't going to come out? Because it always comes out. Just like clients are very eager to tell us about the bad facts about the other party,
Right.
they're just as eager to bring them out. So it is really important that you trust your attorney, you have that rapport with your attorney, you feel comfortable sharing all of those details, so that you guys are ready to face them. Sometimes it's better even for your attorney to bring it up first. And so that can be like a strategy, especially, when you're working on that, of how you're going to address those in a trial. So also something that can be kind of a challenge working through is if you are going to end up in a courtroom, and of course you're going to be preparing for that along the way. There's going to probably be a lot of discovery. There's going to be requested documents. Those are going to be exchanged. So talk a little bit about your thoughts on the importance of complying with those requests, producing the documents, and how it can be helpful to your attorney in terms of preparing for that trial.
Right. Yeah. I mean, definitely throughout the litigation, you are going to have discovery requirements. You're going to have to produce information. You're going to have to respond to questions. You want to make sure that you get that information to your attorney by the deadline that the attorney gives you, because I promise you, we are giving you the deadline for a reason. There is a lot that goes into, responding to discovery. We want to make sure that we have the opportunity to review everything. We want to make sure that you have that we have the opportunity to review, to make sure that you've responded thoroughly, that you've provided all of your documents, that we have the chance to maybe edit responses if needed. And then that kind of ties into the trial prep, because those discovery responses, anything you say can and will be used against you. And that is definitely true in a family law case as well. So we want to make sure that those discovery documents that are exchanged early on in the case, that those discovery responses are accurate. We want to make sure that that you have produced all the required documents. But then I think even more importantly, when you do get time to actually, where you are kind of in the 11th hour of preparing for trial, the sooner that you can get your attorney the information that they need, the more time they are going to have to organize it, to review it, and make sure that that we have it ready for use at trial. So
Right.
that's probably one of the most important things is, you don't want your attorney on the phone to you the day before trial. Where is this? Where is this? Where is this? Because oftentimes we ourselves are under deadlines to get information to the court prior to trial. And if you aren't getting it to us when we need it, then that affects our ability to get it to the court. So
Absolutely, 100%. And it can be time consuming. Sometimes you have to go back, you've got to dig, you've got to find those financial statements, those retirement statements, the credit card statements. People sometimes want to produce different pictures. There's all different types of documents, different types of requests. But you're absolutely correct. It's, one of the most important pieces of properly preparing for trial. The more time your attorney has with that information to familiarize themselves with it, to get the timelines together, it's priceless, and then there's a lot of claims that we're not able to prove, and we're not really able to be successful on unless we have that documentation, unless we have those statements. So starting early with requesting some of them from your different financial institutions, that can be important as well. If you wait till the last minute, you might not be able to get some of the ones that you need, and you're not able to, potentially properly comply. And I think it also is important when we have a client or an opposing party who doesn't comply with the discovery request and doesn't produce those documents, and then we end up in court potentially on a motion to compel prior to trial. It's not always a great look. It's not great optics to be before the judge, who's most likely going to hear your trial, and we're there, and the court is reprimanding us, saying you have to produce the documents. So there's that piece of it as well. If you're keeping in mind that you're always preparing for the possibility of ending up in trial, you've got to be really careful about why you end up in the courtroom, and it can really be off-putting if a client's really just not cooperating with those requests. So, I think that's really important. So, last but certainly not least, also just as important, I think, is the actual meeting with your attorney, right? And having that, what really should be an in-person meeting, to prepare. So, give us some of your thoughts on that and how best to navigate that to be successful if you do end up in the courtroom for trial.
Yeah, definitely. I think it is very important, especially for trial, that you meet with your attorney, that you do a walkthrough. You kind of walk through your questions that your attorney is going to ask you, because really realistically, testifying is nerve-wracking. I'm in the courtroom every day. I've had to testify, nothing major, but it was like 5 minutes, but still it was nerve-wracking. And it's something that I'm used to dealing with day in, day out. But, this is something that, most of us are not used to doing. And so, having your attorney kind of walk through the questions, even if you don't do your entire direct, just at least a partial, so you get a feel for what to expect, so your attorney can get a feel for, okay, what information are you providing? How are you responding? What pointers can your attorney give you for responding? I think that is invaluable. Another aspect to, meeting with your attorney and kind of going through some questioning is, have your attorney do kind of a simple cross-examination, because at trial, the other party's attorney is going to be able to ask you questions. And most of the time, those questions are not going to be as easy as the ones that, your attorney is asking you. So I think it's important that you get a feel not only for responding to direct examination, but responding to and handling cross-examination, because cross-examination can sometimes be tough, and it can be hard to kind of maintain your composure, so to speak. So walking through that and getting that practice can really help you when it does come time to testifying in front of a judge. And sometimes I go to court and it is so painfully obvious that the other party has not done anything.
Yes.
And I think that if this is something that your attorney doesn't offer, you need to ask for it, because at the end of the day, this is your case. And for the most part, you are the boss. Your attorney's got a little bit of decision making, but for the most part, you call the shots. And, basically you get one bite of the apple most of the time. And so you want to make sure that anytime you are in court testifying, that you are presenting the most effective case that you can.
Yeah, no, absolutely. I couldn't agree more. It is, to your point, it is nerve-wracking, even for attorneys who are in their day in and day out. And I think just, also talking through, I think the, kind of the mock of a direct exam and even cross-examination, to your point, because how a party responds on the stand to different questions, to different facts, like we were talking about earlier, some of those ones that you probably don't want to highlight and you don't want to come up, but they are going to inevitably. So just being prepared to know how you're going to, even people's facial expressions, small things that they don't really think about. But if you have that conversation with your attorney and you kind of practice, lack of a better way to put it, then you really are in a better position, because that's a big part of being in trial, is how you react to different questions, how you handle them, your familiarity with some of the exhibits that might be shown. So yes, that meeting, and like I said, and you said, doing it in person, I think, can really make a big difference, your body language and kind of working through that. So, well, Diona, thank you so much for your time. This has been fantastic, talking through trial preparation, and hopefully it has been helpful and insightful for others. Just a reminder that if you are looking to get some legal advice, please reach out and schedule a consult. You can do so by calling 1-866-DADS-LAW, or you can visit our website at CordellCordell.com.